Well, hello, my friends. Welcome to me, your host, Christian Watson. And if you're in the United States, as of April 19th, 2022, you can breathe a little bit easier if you're a frequent traveler. Indeed, the constitutionally adhering judge from Florida, the Middle District of Florida, Kathryn Kimball Mizelle, I hope I'm saying that correctly, just struck down the CDC's nationwide mask mandate, which basically made people who traveled in public transportation and airports, on airplanes, any kind of transportation that was indeed in the public realm, made them wear masks. Now, this decision was immediately met with critique, but rather the decision itself was met with critique. But before the decision was met with critique, Judge Mizelle herself was met with critique. Indeed, if one Googles Judge Mizelle's name, they will see a bunch of articles that report on her ruling, but they frame her ruling around one thing. They frame her ruling around an ABA, American Bar Association ruling that basically says she's unqualified for her position. And blue check marks on Twitter have been taking this line of reasoning and using it as a bludgeon to attack and invalidate everything that Mizelle did in this ruling. Now, of course, there are some sophisticats that go a little bit further. AboveTheLaw.com wrote an article basically using appeal to ridicule, reductio ad absurdum, to go ahead and attack her for her reasoning and her decision, which we'll talk about in a second, and basically insult the judge and insult her intelligence. And basically the Above the Law article concluded that Judge Mizelle just showed how unqualified she was. Now, when we talk about qualifications here, we have to ask ourselves by what standard? And of course, the standard that these people are using, that so many on the left are using to besmirch Judge Mizelle's good name, is a standard created by the American Bar Association. Now, that standard says, and renders her unqualified, because it says that to be qualified, a lawyer has to have at least had 12 years of trial experience to be qualified. Now, Judge Mizelle, for those of you who are unbaptized with this knowledge, actually tried 2 cases to verdict. She served as co-lead counsel to 2 white-collar cases, and when this fact that many leftists are now using to attack her was brought up during her confirmation hearing not too long ago when she was nominated and confirmed for her seat, she said that the methodology the ABA is using does not take into account those 2 cases that she tried while in law school, by the way, which is quite impressive for a law school student to be doing that kind of stuff. Is quite impressive. They don't take into account at all. So how is the methodology sound? And yet news publications like the Washington Post and other people on Twitter and Vanity Fair and all these places are just incensed by the fact that she does not fit a standard set by an institution without asking the philosophical question, is the standard sensible? Is the standard just? And does the standard make any sense for us to apply in this context? And of course, if someone, regardless of if they had graduated from law school or not, had tried 2 cases and basically assisted and did the clerical work for those cases, was the backbone of the effort for those cases, would that not therefore qualify someone to have some kind of legal reasoning? I would think so. Not only that, but Judge Mizelle also clerked for Clarence Thomas. Now, Supreme Court clerks, they do a lot of stuff. It's a very intense job. It's not some lowbrow position. But regardless, the attacks on her qualifications are not meant to be substantive. Rather, they are simply another form of the ad hominem fallacy applied to someone who those on the left now dislike because of their legal reasoning. Now, of course, again, there are those who critique her legal reasoning and think that it's silly. I don't think that it's silly, and I'll be very brief because that's not the topic of this video. Essentially, Judge Mizelle's reasoning for striking down the mask mandate is essentially the word sanitize as defined in the Public Health Service Act, which was the basis for the mask mandate, has many different meanings. Congress was vague about those meanings, so we have to use a textual approach, which means we have to go back to the time when the act was passed and see what Congress may have meant by that, and then apply that meaning in our current day, and that meaning precludes the government being able to impose a mask mandate on you. That's the very basic argument. that Judge Mizelle makes. This is an argument that textualists all across the legal system make as well. It is not particularly all that radical, but it is disdained by people who dislike textualism and who dislike trying to interpret the original intent of Congress. And there's a question. Hey, there is a question as to if congressional intent should matter over the ethicality of a certain law. Personally, I wish more judges would cite, as opposed to being bound to stare decisis, where they are expected to kowtow the past generation's rulings without regarding those rulings with any philosophical or ethical mindset. I would like it if we went back to the days of Justice John Marshall, when judges were quoting natural law theory and philosophy, as opposed to being bound and shackled by the chains of common law. But that's a different story. The big story coming out of out of the critiques about Mizelle, however, reflect the tyranny of the expert. Over the course of the COVID-19 pandemic, we have seen experts deferred to in almost every single case as it related to how to handle the pandemic. And look, this is typically okay when the experts are confined to an advisory role. But unfortunately, those experts were not merely one advisory voice amongst many. Many of those experts were one or two advisory voice amongst a few politicians who then used their sentiments to justify the mass violation of rights on a global scale, whether it be the United Kingdom, where Boris Johnson basically said that this is not about liberty, that liberty is essentially secondary to, well, his actions said it rather, a liberty is secondary to public safety, whether it be with Emmanuel Macron, who said that he wants to go ahead and bully the unvaccinated out of existence, essentially, whether it be with with several states in the United States that apply the advice of Dr. Anthony Fauci, and Joe Biden, who also applies that advice and attempted to institute a vaccine mandate, which was thankfully struck down, was implemented through OSHA. There have been times when experts have intersected with public policy, and the question becomes, when an expert is no longer an advisor on something, doesn't the significance of their role change? And B, doesn't the standards that we should apply to them change as well? Well, my friends, we ought to also ask ourselves, what is an expert? Because Dr. Fauci may be an expert in epidemiology, but is he an expert in ethics? Perhaps not, and actually explicitly not, given the fact that he has suggested many things. Hell, he has even been okay with how the Chinese have been trying to handle the virus in Shanghai, which is another moral catastrophe all on its own. Expertise, my friends, is inherently limited, and it is temporal. The Renaissance men of yesterday are made a mess of as time passes. They are essentially reduced to ashes with the passage of time. This is not to say that Da Vinci's paintings do not inspire something wondrous within our soul, but this is most certainly to say that Da Vinci's paintings and the beauty that they had in their era, while they still may be beautiful today, are put to shame, or can be put to shame theoretically, by a digital construction known as an NFT. Again, the Renaissance men of yesterday are made a mess of by the passage of time and the introduction of the Renaissance men of today. Or not the Renaissance men, of the skills men of today. Expertise is a constantly evolving thing that goes ahead and evolves with the progression of knowledge, because all human beings are bound with this sort of epistemological chain called the knowledge problem. And the knowledge problem, as far as I understand it as a student of philosophy, simply says it is impossible to know and understand everything about the world or everything about a particular concept, and therefore we have to act with the best knowledge that we have. Now, of course, the obvious issue with this is that the best knowledge we have could be flawed. This is why epistemic humility is so important. And yet, those who critique Mizelle on the basis of her not being an expert are not at all exuding the need for epistemic humility, and are instead using their preconceptions as a tool, as a hammer, to beat into the ground a judge whose decision that they fundamentally disagree with. This is not a matter of her qualifications. This is not a matter of her not being sanctioned by experts. This is a matter of political disagreement bequeathed through the appearance of objectivity conferred upon something by the commission of experts. And what do I mean by that? What I mean by that, my friends, is that the American Bar Association is being exalted as a sort of divine entity, this end-all be-all of knowledge, this end-all be-all of legal knowledge and legitimation by these people who are critiquing her. And they're not even willing to engage with the ABA's, again, criteria. Why did the ABA omit the 2 trials that Mizelle tried? Why? And shouldn't that be a black eye to their supposed expertise or experthood? I don't want to poison the well, my friend, which simply means that I don't want to present unfavorable information to destroy my opponent's character as opposed to engaging in his arguments. But it is probably wise for us to know that the ABA, this is the same ABA, which has a full inbuilt DEI program within their quarters. This is the same ABA that carried water for critical race theory and basically wrote a big defense of it after President Trump signed executive orders. This is the same ABA which is notoriously politically biased towards the left. This is the same ABA that is captured by these postmodern leftist ideas like DEI, which are inspired by DEI at least, and they use them as a part of their organizational philosophy. This is the same ABA. Now, of course, this is not a reason to dislike their criteria. Their criteria stands or falls on its own. But here's my main point, my friends. Just because the ABA has a qualification criteria does not mean, because they are the ABA, that the qualification criteria is therefore valid. The qualification criteria is either valid or not on the basis of if it makes sense. And if it omits 2 substantial developments in this woman's career that would establish a sense of qualification in any other circumstance, then that standard is probably not wise. But the sort of acceptance, the blind acceptance of this criteria as the proper way of understanding Mizelle's qualifications, which also is a straw man against her argument, because attacking her qualifications is akin to attacking her character ad hominem, as opposed to actually understanding the argument she tried to make. But to use that is to just blindly accept that the ABA must be a body that has experts in it. It's not very easy to do good philosophy, make good arguments, and have sound ethical judgments when you are in an environment such as we are in this current age, where appearances seem to transcend substance, and political activism undermine the very basis upon which the law in the United States is constituted upon, and that is natural law. And for the ABA to be an organization pushing critical race theory and pushing DEI and pushing all manner of left-wing hellish ideas, and then for others to present them to me as if they are some paragon of validation and certification, is simply, my friends, it boggles the mind. Question everything. Question your sacred cows. Question those who you suspect hold the specter of legitimation and truth. Because just like the Pope in the medieval times, or just like the king in feudal Japan, just like any other ruler who claimed to have immense power to confer truth upon things, it is likely when you peer behind the curtain, the truth is not found in a man or an institution. The truth is found in the world, and all of us can access the world through our powers of observation, bequeathed upon you by either your creator or nature, whatever you prefer, but which reside solely in your mind, your powers of reason. Use them. Do not abuse them or forsake them. Think on it. My friends, love you guys so much. If you love me, patreon.com/PhilCWatson or PayPal, officialcwatson@gmail.com, or you can get me on my Discord, which is in the comment section down below. Or please join my locals. I'm trying to build my locals up, christianwatson.locals.com. My friends, like this video, share this video, subscribe to this channel. This message is dynamite. We need to get it out here. I love you guys so much, and please stay pensive. Bye, guys.